This is the first case on the 11 o'clock session, so I just want to reiterate that, as you know, each of you are allotted 20 minutes to make your argument. And as the appellant, Mr. Benson, you may reserve up to 5 minutes for rebuttal. And believe it or not, I've got the little timer right here ready. And so whenever you're ready, please proceed, Mr. Benson.
Thank you. May it please the court. My name is Joe Benson. Me and co-counsel Margaret White Small represent the appellant Anthony DeLoach.
Very good, sir.
At this time, we respectfully would request 5 minutes for rebuttal.
Very good, sir. You may proceed.
Thank you. Your Honors, the issue in this case centers around the trial court's interpretation of terms in a marital settlement agreement that outlined the tax obligations to the parties. I believe a brief summary of the underlying facts will assist the court. We are here solely because of the actions of the former wife, Lori DeLoach. The parties jointly owned 50-50 a corporation called Water Equipment Services Incorporated. In the summer of 2013, the former husband learned for the first time that the corporation had an IRS tax debt as a result of the former wife not paying the corporate taxes and the employee payroll taxes for part of 2012 and the beginning of 2013. Going forward, it's clear that as of 2013, both parties were fully aware that this corporate tax debt included part one, the corporate tax debt, and part two, the employee payroll taxes. At that time, the parties were under the impression that the entire corporate tax debt was not collectible against the corporation due to the financial situation of the company. However, a portion of that tax debt, the IRS was able to go after officers of the corporation individually for the unpaid payroll taxes. 2014 comes and the dissolution of marriage is filed by the former husband. February 15th of 2015, almost 2 years after learning of the IRS debt, the parties entered into a marital settlement agreement that was titled Stipulation for Final Binding Settlement Agreement. This marital settlement agreement is probably unlike the typical agreements found in family court. It was drafted by the former husband pro se and included essentially the first half of the agreement deals with the former husband's obligations to the former wife. The second half of the agreement deals with the former wife's obligations to the former husband. Former wife was able to review and contribute to that agreement and had the benefit of counsel during the entire time. 2 days after the agreement was signed, on February 17th of 2015, the IRS asserted or assigned that personal lien, the personal tax consequence against Anthony DeLoach. And that tax lien attached to the marital property located on Thicket Lane. Your Honor, the court's conclusion on reading the language in this agreement came to the erroneous conclusion that the clear language of the agreement made my client, the former husband, responsible for 50% of the individual tax liability and 100% responsible for the corporate tax penalty, wherein he had nothing to do with creating that problem, and in fact was absolved of any obligations through the abatement he received from the IRS. Despite that, the court found that the clear evidence, and again, the court's focus primarily during this 3-day trial was on the husband's paragraph 8. And based on paragraphs 8, the court concluded that Mr. DeLoach was responsible or was agreeing to pay 50% of this individual tax debt that in the court's estimation had already been assigned, when in fact we know that that was not done until 2 days later. In fact, as of the date of signing the marital settlement agreement, the parties themselves weren't even sure if it would ever be asserted by the IRS, because all it was a anticipation or expectancy. It wasn't a certainty. Despite that, the court attributed or filled in language in the husband's paragraph A to obligate him to pay for 50% of a past IRS debt that had not yet been assigned. And the only way you can come to that conclusion that the court was assigning it or was attributing a past IRS debt was the fact that this thicket property under the former wife's paragraph 2, when the husband signed over his interest to the wife for this marital property, the wife reciprocated in her paragraph 2 by releasing him from any obligations, from any claims, either by lender, personal, or third parties related to that property. So what happened was the IRS lien attached to the property, and the wife had to satisfy that tax lien in order to close the sale. She closed the sale, was able to pay off the mortgage, pay off the IRS debt, and still walked away with $100,000 profit. Now she's trying to come back and say paragraph 8 of the husband's MSA obligates him to reimburse her for 50% of that debt.
It does talk about IRS debt, correct? It does explicitly say IRS debt.
Yes, Your Honor.
Okay, and Mr. DeLoach knew there was a tax penalty coming down the pike, and he did whatever he could do to try to abate it, correct?
Yes, sir, and he got the abatement.
And then in paragraph 8, he explicitly agreed to assume 50% of the current IRS debt. And that lien that was placed on the thicket house was not a contractor's lien, was not a mechanic's lien, was not an electrician's lien. It was a lien from the IRS, wasn't it?
Yes, sir.
Okay. Why doesn't that cover it?
The language in paragraph 8 compared to the other paragraphs addressing the IRS tax as explicit limiting language that is not found anywhere else in the agreement. Paragraph 8 only applies to joint debt assigned to the couple. It does not assign debt. He is not assuming debt that is attributed.
Wait. Hold on. I'm looking at paragraph 8, and it says Anthony DeLoach agrees to continue to assume 50% of the current IRS debt assigned to him and to Lori DeLoach.
Yes, ma'am.
Those are the words that, pro se or not, were written in this contract and that we're tasked with interpreting.
Correct, Your Honor. So my position, Your Honor, is that paragraph 8, because again, when you take it in context of the entire document, there is no other limiting language. Paragraph 8 is unique compared to the rest of this document.
Well, paragraph 14 under her obligations says Lori DeLoach agrees to pay her 50% portion of the IRS debt.
And Your Honor, the difference between the two is that paragraph 8 of the husband talks about joint debt that's assigned to both Mr. DeLoach and Lori DeLoach. It doesn't separate them out. Whereas the rest of the documents recur to the IRS debt. As I was explaining in the beginning, the parties understood that the IRS debt included the corporate portion and the employee payroll portion collectively. That was the IRS debt that was understood by both parties. So our position is that paragraph 8, by the fact that he drafted this purposely because he understood that he should not be held responsible for a debt he did not create. So that's why he was trying to limit his personal liability as much as possible, which is why he put in there that this was going to be any joint debt from the IRS.
But wasn't this a corporate tax penalty from the operation of WES? Otherwise known as water?
It was a corporate tax debt from Water Equipment Services that later became WES.
Okay, so let's just call it water for short. So, and you would agree with me that via this MSA, he assumed exclusive ownership and control of WES.
I do not disagree, Your Honor. Correct.
Okay, so what you're trying to do, it seems to me, is you're seeking an order to hold the former wife responsible to pay corporate taxes that the husband knew were coming down the pike for a corporation that he took over complete ownership and control. And you're trying to say that this MSA says exactly that this wife is going to pay whatever corporate tax and penalty WES incurs. And there's nowhere in here where it says the wife is to assume any corporate tax liability. Where is it?
Your Honor, the difference here, or what I should say, is the paragraph that you're referring to, that the husband acquired water from the wife. Wife in her section, under paragraph 17 of the agreement, she signs over water to him and holds hard. And the problem is the language in that is limited to, is not a complete hold harmless about everything. Their husband specifically put language in that transfer to leave open the possibility, or actually our contention is to leave open the responsibility of the former wife to be responsible for this tax debt that she created.
Where does it expressly say that?
It doesn't expressly say that, Your Honor.
Because you're trying to use that same type of argument about her total control and ownership of the house, and she indemnifies him for third-party claims. So you can't have your cake and eat it too. Which is it?
Well, I think they're both different, Your Honor. The house hold harmless clause that was included had very clear language about the limitations of the liability that was being assumed. And in the husband's paragraph about the house, it was very clear that when his husband signed over the house to the bank, that the understanding was he was walking away from any liability to that house.
Except that the MSA, we can't disregard paragraph 8. You would agree, right? We have to give that provision its meaning and effect, assuming there is one.
Yes.
But I don't think anybody contends that there is an ambiguity here, that Anthony agreed to assume 50% of the IRS debt assigned to him and to Lori Deloach for the former delinquency. And this may be overly simplistic, and you can educate me, but the way I understand your request for the relief that you want in this case is to absolve Anthony from his responsibility for that 50% of the debt that was taken out of the proceeds she paid from the Thicket house. So how do we reconcile paragraph 8 and the fact that Lori ate the 100%, and now your guy doesn't want to take his 50%?
Your Honor, I think the only way that you can that this marital settlement agreement makes sense is if you look at paragraph 2 of the wife dealing with the property, and you look at the paragraph 8 of the husband. To reach the conclusion the trial court did, the court did was delete that section of the wife's paragraph 2. Because wife's paragraph 2, our position is explicitly removed him from having any liability attached to that property, and that is what the court found in the earlier trial on when we were trying to argue the proceeds, was that you take the good with the bad. And so the wife got the benefit of the husband got the benefit of walking away from any liability, and therefore he's not entitled to come back and look for proceeds. Then
we have to read paragraph 14 under the wife's as well. And that says that she's taking 50% of the IRS debt. It doesn't say she's taking 100%, and it had to be there for a reason under her section. And if it was there for a reason, then we have to read it together with the hold harmless that you're talking about earlier in her part of the agreement. And I don't see how we get there from here with those two provisions.
I think the problem is that the two provisions, our contention, addresses two separate tax issues. The wording in paragraph 8 applied, and it was uncontested. The trial testimony from both parties was that paragraph 8 was directed only towards the personal debt from the IRS. Okay, and that our contention is that the wording in 8 is drastically different than in paragraph 14 of the wife. Paragraph 8 has very limiting language compared to the rest of the document, which indicates that the parties intended to only obligate themselves to a joint debt. And if there was not a joint debt, then the husband was not going to be responsible for any of it. The husband, in
Can I
fact,
interrupt you, Mr. Benson? You're about to get into your 5-minute rebuttal, so feel free to go forward as you deem fit, okay?
thank you, Your Honor. So what we have here, Your Honors, is that the trial court, in essence, saddled the former husband with 77% of the actual monetary amount owed, and the wife walked away with only owning 23%. We believe that the language, by the clear restriction or restrictive language in 8 that is not found in the rest of the paragraphs, clearly indicate that there was a different intention. Your Honor, I reserve the remainder of my time for rebuttal.
Very good. Thank you, Mr. Benson. All right, and if I could trouble you, Mr. Benson, to mute your microphone. Okay, Mr. Cole, you are all set. You may proceed.
Thank you, Your Honor. Good morning. This is Richard Cole on behalf of the appellee, Lori DeLoach. I think there are two issues, the corporate portion and the civil penalty, that might be viewed somewhat distinctly. As to the civil penalty, Lori took the home in the marital settlement agreement, and then subsequently a lien was placed on it for Mr. DeLoach's civil penalty, which arose from the corporation, but was ultimately a personal obligation of the parties. She had to pay that in order to close on the home, which resulted in her paying 100% of the tax obligation, including all the taxes that were personally assigned as a personal obligation to Mr. DeLoach. The abatement only came after she had already paid that 100% of the tax debt, and much is made of that abatement. We don't know why the abatement occurred. There's nothing in the record as to exactly why it happened, but it's logical to assume because she had paid 100% of that tax debt, the abatement would be granted since it's no longer collectible. She has paid it. Ms. DeLoach cannot get a refund for what she has paid to the IRS on those abated taxes that she paid. They were ultimately taxes of both those parties, and they were the only taxes that were contemplated at the time that the marital settlement was executed. As that parties testified, that is what came in the parole evidence before the court, was both his testimony and her testimony indicated that when they signed this agreement, what they were referring to was the TFRP taxes, or the civil penalty, that they were both personally liable. They were not referring to corporate taxes that were solely tax debts of a third party, water, and that will never be collected against these parties individually, cannot be collected by these parties individually.
And if
So
I
Lori,
can interrupt, Mr. Cole, let's focus on the water company. And you raise in your brief, and I just want to make sure I have the timing correctly. The marital settlement agreement was entered at a specific time. Then it appears that the company water that the former wife went ahead and provided and basically assigned all her rights to former husband. He did not keep the company. Basically, he changed that company and it became, what is it, WES? That's the new company. And help me out. You're taking the position that at this time when he changed it, or he basically, it became a successor entity, that's one of the reasons why the IRS followed him, because it was almost like a continuation of the prior one, and whatever corporate liability that basically came into play when in May 2018. That is what, well after the signing of the MSA.
That's correct, Your Honor. Water was an environmental remediation company that the parties had run together during the time of their marriage. At some point, the party's son, Travis, opened Wes, and Mr. DeLoach eventually took over Wes. You see Wes referenced in the MSA since Lori agrees to waive any right to own any interest in Wes for 50 years. Mr. Deloach clearly knows how to speak in the future tense when he needs to.
And this is kind of interesting, which leads me to this. There's nothing in the marital settlement agreement, since Mr. Deloach is the one that prepared it, nothing that said future corporate IRS. It just mentioned IRS debt. So is that something that we should look at as well in making determination as to, the drafter in this case?
Yes, Your Honor, we have to look at what the parties intend at the time they execute the agreement, not subsequently to it. And by using the word, for instance, assigned, which the brief makes quite a bit of, the brief is trying to say that assigned should be read as a future tense, but it cannot be. Under the standard rules of English grammar, it can only be preterite, present perfect, or past participle. So once he uses assigned, he's obviously only referring to old tax debts, and the way it's used is only personal tax obligations of the parties. The corporation, Wes, that's a valuable entity. It's could be able to pay its own tax debts. Tony takes that with all the benefits of that company. Since he's able to run it, he has the benefits, the ability to profit from it, the ability to extract income from that corporation, generate funds to pay these tax debts. Lori is waiving all her rights in Wes. She can no longer operate the company. She can no longer benefit from it. She can no longer generate income to pay Wes's tax debts that are truly just the debts of this third party that is not a party to the marital settlement agreement. It's plain from the plain terms of the agreement, but also from the parties' parole evidence that the court allowed in, that what they are intending to talk about is their personal obligation, the civil penalty that...
I have a question for you with regard to the use of the term assigned and the timing, right? The notice of the tax lien reflects that the penalty, which they knew was coming, was assessed in March of 2014, which was before the settlement agreement was signed, but they knew what was coming. So is it a fair reading of assigned to be the payroll tax debt that they knew was coming, and that the notice issued within a handful of days of the signing of the MSA, but the notice itself says it was assigned as of March 24th, 2014. If you could speak to that.
The parties were quite aware that there would be a civil penalty when they executed this marital settlement agreement. They may have also known that there were some issues regarding Wes, but what they said in the marital settlement agreement goes to just the civil penalty, which was divided 50-50 according to the terms of the agreement. So Lori still has had to pay half of that civil penalty. She's simply asking that Mr. Deloach also pay his half. The fact that she received Thicket doesn't absolve Mr. Deloach of his obligation to pay his half. It doesn't matter when or how the funds came about that she was able or required to pay that IRS tax penalty. What matters is that it was paid, and she is therefore entitled to contribution because she paid the full amount of the debt, and she is entitled to that one half to come back. And that is what these paragraphs are saying when they indicate 50%. So assigned, it means past tense because the parties knew about it. But they certainly were only referencing themselves individually. They weren't saying Anthony Deloach and Lori Deloach and Wes Industries taxes. They said just Anthony and Lori. They're just indicating their personal obligation. There's nothing in the agreement that would suggest some third party is entitled to benefit, and it would be completely an unreasonable interpretation of the contract to imply that, especially when Lori is losing all of her interest in the company that could pay that debt. I can't read that. So I think that the contract is designed in this way specifically. Anthony also basically impeaches himself when he says that, oh, it's all Lori's fault. That can't be believed. He signed an affidavit with the IRS, the taxpayer interview form, that, he was president of Water. He had knowledge of what was going on, of its operations, its taxes, and so forth. So, he changes his testimony from the time he interviewed with the IRS to the time when he is in court. So it's unfair to say that Lori is the one who is solely and only responsible for the tax debts arising as against water. He's either impeached himself or it's not truthful. It's just not realistic to assume that a sophisticated business operator such as Mr. Deloach has no responsibility for the fact that water had these tax debts that arose. And, they make much of equitable considerations, but this matter sounds in contract. There really can't be an equitable consideration for this court. There was no exploration of factors under 61.075 in the trial court. So there's nothing here to say that there should be an equitable consideration taken into account in any event, even assuming that would go in Mr. Deloach's favor. We're just looking at a contract. And even if Mr. Deloach thinks he got a bad deal, he has to live with the contract. And in fact, the court took on the parole evidence that does nothing to dispel what the court has found. And the court found specifically the parole evidence supports its findings that he must reimburse her for 1/2 of the proceeds paid on the house. And that the tax debt of water, which is solely Wes's obligation, it's not her obligation. She has no obligation to reimburse him or pay a corporate tax debt that the individual parties, Anthony and Lori, they will never have a personal obligation to pay that. It just belongs to that corporation. Anthony has many different options to either use that company to pay it or to try to start a new company and see if he can avoid a successor and interest being imposed, among other options that he might have. So certainly patently unfair to have Lori pay any portion of the corporate tax debt. We're just not proceeding in equity. Many of these arguments, I believe, are being raised for the first time on appeal. They weren't necessarily raised at the trial court level. And Ms. Deloach denies that she contributed to this agreement. And the TFRP issue was always known to the parties. We simply have to look at the contract at the time it was executed. We look at its plain terms and meaning, and the trial court correctly concluded what that meant. I think I will yield the rest of my time unless the court has any further questions.
Judge Sleet or Judge LeBret?
None for me.
Very good. Thank you, Mr. Cole. All right, Mr. Benson, you have about 4 minutes left for rebuttals whenever you're ready, sir. And could you unmute your microphone, Mr. Benson, so we could hear you?
Thank you.
Excellent. Thank you, sir.
Thank you, Your Honors. There's a lot thrown out by Mr. Cole. I will address a few things very quickly. The misrepresentations made that Lori Deloach had nothing to do with this, or that Mr. Deloach's changing his testimony is a misrepresentation of the record. It has never been alleged that Mr. Deloach, and it has never been implied that Mr. Deloach had any obligation or had any participation in this tax debt that was incurred solely as a result of the former wife. In fact, the abatement that was obtained by the IRS absolved him of any fault. Therefore, he did not have any tax responsibility for that individual tax assessment according to the IRS, which leaves only the other remaining officer of the corporation, which was Lori Deloach, as being solely responsible. Next, Your Honor, the fact that you signed, when Lori Deloach signed over water, there was no limiting language to her liability of signing over water. And that was deliberate because water had this tax debt. When I say the tax debt, that encompasses both the corporate and the civil side. So back in 2013, when they realized there was this overall tax debt, that's what's referred to in paragraphs 22 and the wife's paragraphs 14. And that only can make sense that way because you have paragraph 8, which is distinctly different than the rest of the document, which only obligated Mr. Deloach to be responsible for any joint debt, because Mr. Deloach realized he wasn't going to be found responsible for this debt. Now, whether or not the company debt is a marital debt, we're not disputing that. But the parties are free to contract whatever obligations they want that obligates them beyond what they normally would. And our contention is that Mrs. Deloach understood at the time this MSA was signed that they had this overall tax debt that was hanging over there. And maybe she felt guilty because she was responsible for that. So when she signed over water, she purposely didn't want language included in there that would have absolved her of any responsibility for water. That's why the all-encompassing language in paragraphs 14 and 22 say the IRS debt. That's all-encompassing, because that's what the parties understood. Next, Your Honor, the assigned tax debt was not assigned in 2014. The corporation had an assigned debt for the entire portion. The personal assignment did not happen until 2 days after the MSA was signed. And it could not be contemplated that that was going to happen because it was not a absolute. It was a projection. It was maybe a possibility, but there was no certainty that the IRS would ever follow through. Finally, the whole purpose of saying that the West Industries as the successor in interest to Waters' debt shouldn't be the appellee shouldn't be responsible for that. It's kind of misplaced. The IRS debt was an IRS debt to Water. That followed into West. West wasn't creating a new IRS debt. That was an IRS debt back from 2012 and 2013 that the IRS determined they were responsible for. That followed her. To say that it's unfair for her to have to pay a debt that she caused, I don't know if that can be considered genuine. I think the outcome of this case, the fact that the former husband had to pay 77% and the wife only had paid 23%, that shows that the outcome was clearly unreasonable and unfair. What the parties could have done, or what the court could have allowed, was under the ambiguity of the terms of the MSA, they could have looked at not what the parties should have done, but what the parties would have done under the circumstances had they known.
Wait, I have to interrupt you. If you're gonna go down that road, then the trial judge acknowledges that he did hear parole evidence and he or she reaches the same conclusion with the benefit of that information. And then you're going to be asking us to delve into the trial court's factual findings. Is that really where you want to go with this?
And Mr. President, just to let you know, you have exhausted your rebuttal, but go ahead and answer the question.
Thank you. Your Honor, the reason why I bring that up, is that the court's focus on this ruling was only on paragraph 8. It did not address the rest of the paragraphs. In fact, what the court did was impose additional terms to make the judgment fit when there was no restrictive languages placed on the remaining portions of the marital settlement agreement. With that, Your Honor, I rest. Thank you.
Very good. Well, thank you both again. Well argued passionately on both sides. All right. Thank you. Thank you all. All right. So our